Hello, everybody. My name is Dennis Raglin, and thank you for joining me today to talk about consumer chemical regulation. A couple things before we get started. There's going to be a lot of information here that we're going to cover, and you're going to see a lot of text-heavy slides. But don't panic, because I'm not going to go through them and read line for line. I'm hoping to give folks some information, however, as a reference for the future, if you might want to go deeper on some of this. Hopefully it'll be useful to you. Nothing in these slides, nor what I say today, is legal advice. These are my observations based on my experience. These are incredibly complex laws, as most of you probably already know. And so you need to seek compliance advice from someone in that area, an expert, including me, but you'd have to talk to me after this event. The webinar is being recorded for a couple different purposes, and it's going to be available to you after today. We'll explain that at the end. And there will be members of the press in attendance based on our RSVP list. And so I'm giving folks advance notice of that. All right, so who am I? I've been in the Carlton Fields, Los Angeles office since November. We're establishing a Prop 65 and consumer chemicals group here. I've got about 30 years experience in this area. I defend manufacturers, retailers, distributors, and you can see here some of the things I do are some of the things you're dealing with. Obviously Prop 65, but things we'll talk about today, recycling, microplastics, greenhouse gas reporting. All of that space is my wheelhouse. I've achieved a couple of defense verdicts in Prop 65 cases the last few years. Prop 65 trials are very rare, but I'm honored to have helped our defense, our clients, and prevail in those cases. I was also part of a team that the Court of Appeal established that Prop 65 is preempted by federal law for over-the-counter drugs, generic drugs. So with that, let's talk a little bit about what I see as the roadmap for the short time we're together. We're going to talk about an overview of these chemicals. We're going to talk about Prop 65 a little bit. I'm going to assume that most of you here have some working knowledge of Prop 65, so I won't be going into this is what the law is, this is how it works. But if you need that type of information, please contact me offline and we can discuss some resources for you. Also, PFAS will be one of our topics, as will microplastics. We're going to talk about producer responsibility and recycling, as well as briefly talk about misleading advertising. Some of you are probably seeing or understanding that there's an increase in consumer class actions in this area. So we want to talk a little bit about that. And finally, we'll talk about some best practices, how to minimize risk, and go from there. A note on questions, if you have any questions, there's a Q&A feature. Post them there. If I can get to them, I will. If I can't, I promise that I will get to them offline afterwards. All right, consumer chemicals, the regulatory landscape. What are they and why should we be interested? Well, the way I look at it is the things we eat and use on a daily basis. The things that are in those is what we're talking about, right? Whether it's the cosmetics you use, the food you eat, the cleaning products you use, the clothes you buy. These things are all made with chemicals of some sort or ingredients of some sort that are governed by various state regulations and laws. Prop 65 being the granddaddy of them all, as I call it, it keeps on giving and giving, frustration and aggravation. We all know that the warnings are almost everywhere, on your product, online, at gas stations, on and on, at Disneyland, actually. And I won't go through this one, but the question everyone needs to ask is, do I need to put a warning on, right? So there's ways to prove you don't have to put a warning on. And that is an exposure assessment. So this goes through some of that. You're also exempt if you're under 10 employees. That's first. And then second, if you're preempted by federal law. As you heard me say a few minutes ago, over-the-counter drugs, for example, are preempted by federal law in terms of Prop 65 compliance. So by and large, most people do warnings for the expense that it costs to defend these cases and the cost and the expense in settling these cases. So a lot of folks, probably some of you, are putting warnings on products as a prophylactic measure. But if you wanted to find a defense, if you wanted to defend these issues on an exposure, this is how you would do it. And I've helped many clients do exposure defenses with the right experts. Here's what I think is important here. We're starting to see and have seen an industry-wide effect from Prop 65 litigation. What I mean by that is, let's talk about a chemical called bisphenol S, BPS. It's a chemical that is in thermal paper, the receipts you get at the store or the gas station. The paper that is, those receipts are printed on, or the information is printed on, that receipt paper, in many cases contains this chemical, and that's a Prop 65 chemical. So what we've seen is there's been a massive amount of notices of violation served by one plaintiff's enforcer, over 200 defendants, I think. There's a proposed settlement, I think, being negotiated. And so the last I heard, they were working towards that. And the plaintiff would obviously get some form of attorney's fees based on the number of defendants. And so the thing with BPS is there is no safe harbor level established by the state. And what that means is if you want to defend it, going back to that slide I showed you, if you want to defend yourself in Prop 65, you have to be able to show that your exposure is under a level that would not trigger a warning. So with BPS, the state hasn't set that level, and it becomes easier to join settlements. And that's what's happening right now. And so what I mean by industry-wide litigation is this same enforcer has changed the way the industry regulates and sells products. And these are just a few examples: gloves, handbags, jewelry. In all of those cases, so many defendants were named and settled that in the future, from that point forward, it's easier for a defendant just to meet those meet those standards that previous defendants had settled for, so that they can avoid a violation. And so we're seeing it now with BPS in receipt paper. Another example. What's next? So the agency that oversees the regulations for Prop 65, OEHA, O-E-H-A-A, or O-E-H-H-A, OEHA has proposed a couple of things that I think are troubling. They're proposing a class of chemicals. You can see here the entire type of bisphenol chemicals is one they have recently proposed to list. And what that would do is it would affect a company more than just BPA, which is another cousin of the BPS chemical. And it would reflect more than BPA or BPS. It would reflect and affect an entire group of them. There's many of them in food packaging, medical device. You can see there are some examples. So if we're going to do a whole family of chemicals, that creates an issue, as you can imagine. Suddenly, we don't have a clear set of what we're testing for. We're testing for all bisphenols. I think the same issue is going to be potentially a trend with PFAS. Right now, there are only 3 PFAS chemicals on the Prop 65 list. What if they being the agency, decide to list PFAS, period? There are hundreds of variations of PFAS, or hundreds of PFAS within that big family. Same with phthalates. There's not hundreds, but there's many phthalates, some of which are not on the list. So it's troubling in the sense that at least we have a roadmap when we know a specific chemical on these lists. But what if we have a whole family? How do we go about that? Briefly, federal courts have been the only silver lining in terms of court handling of Prop 65 regulations and application. What I mean by that is there is a federal law that 3 district courts now have used or implied to these cases. There's a case here called Zeruder, as you see. Warnings have to be, well, back up. A company has a First Amendment right. It's qualified. You can be ordered to put warnings on if it is factual and if it's non-controversial. An example, lead. Uh, there is no dispute on its causing reproductive harm or cancer, the two things Prop 65 looks for. And it's non-controversial in the sense that there is no dispute among all the journals and agencies. But that's not the case all the time. There's three chemicals here. Let's just talk about glyphosate. That's the chemical in the weed killer Roundup. Well, there was a challenge there to that listing because there is no state agency in the United States or any state that found this chemical carcinogenic or likely carcinogenic. There was no agency anywhere in Europe but for one, and that agency did not say more probable than not. It said probable, possibly. And based on that, the court said there's unsettled science here. And if you're doing that, then you're forcing a company to put a warning on that is not non-controversial and that has not been proven factual. So three district courts and now the Court of Appeal here at the Ninth Circuit has affirmed and issued permanent injunctions against Prop 65 enforcement for these three chemicals. So I think that is a really positive sign. We have no state courts yet here in California who've taken that bait, if you will, or done that, taken us that far. I think these are some cracks in the dam, and I think we've got some future targets based on conversations I've had. I think PFAS might be one of the candidates for the next challenge. And so we're going to see that with other chemicals as well. So that's one, like I said, silver lining. If you're in the food business, that doesn't seem like there are many silver linings at all. I told you about those trials. Those were all food trials. There's also a fourth trial right now, also for food. It seems to be going well for the defense. So if that's the case, it would be, it would be 0-4 for the plaintiff, and that's good, but that's expensive. So as you know, most of these cases settle because it's cheaper to resolve the case and move on than to litigate it with the risk and expense. So what are the trends? We continue to have heavy metals be the main things targeted in food. There's supplements like protein powder, ashwagandha. There's dry food, soup mix, dried seaweed. Those tend to be on the upswing right now. And so let me back up. So that's the trend in what we see right now. Pretty much heavy metals are always, have always, will always be the main targets, whether it's food or not. There was an AG settlement that I think is helpful for the seafood industry. It was focused on frozen and fresh seafood, and there's two different settlements, 2025 last year and then one this year. They have the ability to require certain warnings on the product, certain reporting requirements to the state. If you meet all that, then you're in compliance with those consent judgments. There's opt-in deadlines that allowed other companies to join, but those deadlines have now passed on those two. That doesn't mean you can't take advantage of modeling your warning on the same warning in those agreements. So if that's of interest to you, check out those two consent judgments. So that's somewhat a positive development. As I said, there are the four trials. Three have already been concluded. They are on appeal, but for those three, the defense prevailed. There's also a fourth right now for cadmium in seafood. I've talked with that defense counsel, and it sounds like things are going well. If that goes as well as we think, and if all the appeals are denied, then this will have set a very strong precedent for Prop 65 in food. Most plaintiffs and the state attorney general most of the time are not agreeable to averaging consumption. And that's really the key for food in Prop 65. The way the plaintiffs calculate that is maximum amount of the serving every day, no looking at the average exposure. Well, what that does, maximum dose, maximum day, all the time, is of course gives you a higher number of exposure when you're calculating your lead or your cadmium. But there's a case law called Beechnut in California where the appellate court said they endorsed the ability to calculate exposure for food, based on looking at average consumption, how many times you eat the food, when you eat it, how much do you eat, and how frequently do you eat it over the course of a week or 2 weeks. And that data is in a government database, and that has been used in all four of these trials I'm talking about. So state courts have been receptive to looking at averaging for food. Unfortunately, for settlement purposes, the plaintiffs are not looking at that. They understand that to settle makes more economic sense for a defendant, even if they have a good case on exposure. That's not going to change, even if these trials are successful, which I believe all the decisions will be, because again, if you got into litigating, that'd be one thing. You might be able to convince the plaintiff, but on the front end, plaintiffs know again that even if the court decisions are good for the defense, it's cheaper for the company to settle. Finally, here there's a change in the short form warning. Again, I am presuming that folks watching this have some understanding of the Prop 65 warning. There's the regular warning, and there's the short form. The current short form is on the left. It is going to be phased out starting in January of 2028. You can only use, if you want to use the short form, you have to use the certain types. And this is just one example. There's a few, but in each of them, you have to list the chemical now, or then if you're going to start. I call it the regular warning form light because I'm not sure what benefit you're really getting at that point from the short form. But if you weren't aware, by January 1, 2028, you can't use the short form in its current form anymore. So let's take us out of Prop 65. What does the future hold? I think there are two, as I said, there are two things of concern for me: listing families of chemicals, and then I think the microplastics and PFAS claims, I think, are also of an issue. And we've talked a little bit about how PFAS is listed on Prop 65, and microplastics will be, and I'll talk about that in a moment. So let's talk about PFAS. The thing about it is I call it the new asbestos because I think we're going to see continued litigation on it because it's in so many things, right? So what plaintiffs will do is they'll test it and they come up with what they claim is presence of PFAS. We'll talk about the testing in a moment. They claim they've got the PFAS in the testing, and then they file their notices of violation claims. And then the defense is burdened with how do we defend this? And we'll talk about that in a second. There's also state regulation, including here in California and in many states, that are starting to do bans on PFAS altogether. And I'm sure some of you have had to deal with trying to understand this. It's one thing to say no more PFAS at the state legislature, but then how do we put that into practice if we're a company trying to stay up with the regulations? What it's done, in my opinion, with all these different states trying to do their regulation, is it's created a patchwork. There's many states that are trying to get in on the action, and we'll show some examples, but they're doing it differently. Different deadlines, different definitions, and different methods of reporting. So again, it feeds into the patchwork family, if you will, of these regulations. Like I said, there's a handful now, maybe 15. California, Maine, Minnesota, New York, Washington are generally the most regulatory environment on this, but others are coming. There's a bunch of pending pending legislation that's coming. The typical targets, the low-hanging fruit, if you will, continues to be food packaging. There's textiles, carpets, firefighting foam. Those are also up there that have been phased out or banned in terms of PFAS. But the strongest laws are these here. In my opinion, the strongest laws are these. And I was just going to we'll go through about three as an example. But in terms of PFAS and Prop 65, there's a difficulty here to defend it. Like I said, there's three that are listed on Prop 65 right now. There's four more under review. There's no safe harbor established by the state. And so then if you want to defend these cases, have to prove that the exposure does not require a warning. And as you saw from that slide at the beginning, that's a very complicated process. The federal government has determined that parts per trillion is the way they are going to measure in the water, PFAS in the water. If we're going to apply that to Prop 65, how do we create an exposure that's in the trillionths, if that's going to be the quote unquote safe harbor? How can we do an exposure assessment and not have to do a warning if we're talking about such a tiny amount in terms of that does not require a warning? So I think that's one of the bigger questions that we have now with PFAS. And there's many questions with PFAS, but I think this one, the interplay with Prop 65 is a concern because I don't see at this point a way to defend it on an exposure basis. And I think that then plays into the other issue of total bans, the presence of PFAS alone. That causes some states to say, we're going to just ban it, period. Well, that's easier said than done, right? For example, Maine will just use, they were the first one to jump out on a total ban. They had proposed, this is a few years ago, they proposed and enacted January 1 of 2030, no PFAS containing products that can be sold in the state. There's a couple of catches there, though. It has to be intentionally added PFAS, and it has to be unavoidable. What do those mean? Maine doesn't know. Nobody knows right now. That's the rulemaking process is ongoing, but let's assume that it is up and running. All manufacturers that sell products in Maine that contain intentionally added, they have to report the product and the PFAS purpose, the chemical, all these things you see here. But how do you know this? You're having to rely on your supplier. What if they don't know this? This is a theme that will be continuing throughout all these chemicals. The regulations aren't finalized, and enforcement supposedly is set to start later this year and will continue into early next. There's no fines issued yet, but the enforcement mechanism is still on the books and still in terms of companies that do business there and meet certain criteria have to report to the environmental agency. There's no penalty yet because the state doesn't know yet how it's going to regulate with these definitions that are still not defined. So that's just one example. Washington State is another. They have phased in system where certain amount of chemicals, a certain amount of products containing chemicals, there's a deadline by which they can no longer be sold. There's a number of phases. So the next, and again, they're using the intentionally added PFAS. What does that mean? So there's different types of products covered, phased in reporting. The first annual report is due in January of 2027. So I don't have time to go through all the details here, but if you haven't, and you sell in Washington, and if you sell in Maine, go to those pages of their ecological departments, their environmental departments' web pages, and become familiar with this, because it's going to become an increasing issue. This is similar to what we'll talk about with EPR. EPR is another example of having to report to states, different requirements, different deadlines. So Washington, Maine, and then Minnesota. Obviously, Minnesota's been in the news a lot, but certainly not for this. This is also modeled on Maine. They have a total ban. Theirs is a little different because they're going to phase it in certain ways, which I think are more helpful than Maine. But they've got different deadlines. There's supposedly a report deadline coming up this year in July. Again, the states are all kind of grappling with what the legislatures have said. These agencies are trying to put it all together. So there's some exemptions, there's some deadline extensions that are available. So again, if you're not familiar with this, let's look at the state, let's look at these state websites and get familiar. The challenges with PFAS, basically the plaintiff's attorneys, for example, in Prop 65, they'll test and they'll say, we've got fluorine. Fluorine is the magic word, and that means there's proof that PFAS is in the product. Now it's up to you, defendant, to show us that you don't need a warning or that you're in compliance. It's also a test used to see if you are in compliance with some of these states that have bans. California has effectively a ban on cosmetics and textiles that contain PFAS. I think it's 100 parts per million. And so plaintiffs will test and they'll come up with this fluorine, which is the magic word, and they'll say, ha, you have fluorine, you have over X amount of PFAS, and you're in violation. Well, not all tests are the same. And that's kind of a theme I want to stress here as we go through. Just because there's a test by the plaintiff or the state does not mean that test is valid. No two tests are the same, so to speak, if they've got different accreditations at the lab, different methods being used, and then how was the test performed? All these things are important. And so for PFAS testing, there's a default method here, the EPA method of 1633. That's what companies tend to, what tends to be considered a valid method. This is kind of all in the science area, and that's why I went to law school, because science is not my thing. So I won't pretend to know all these details. I will say that you need to be familiar with the issue of total fluorine testing versus total organic. There are differences and the test methods matter. So if you've got a PFAS issue and PFAS testing and compliance for PFAS, and if you don't know about this, then do what I did and talk to a qualified scientist in the area or toxicologist. Compliance issues, we just talked a little bit about that. The trend, as I call it, is supply chain mapping for intentionally PFAS added. If your supplier can tell you, great. Most of all, suppliers can't, right? If they're a foreign supplier, they're not going to know what's in it, and you're not going to know what's in it. So the question becomes, if you're the American entity, you're going to be left holding the bag on some of these laws and regulations. So if your supplier can't test or won't test, you should consider testing. And that's easier said than done. I understand. There are more cost-effective ways to test. It doesn't have to be hundreds of thousands of dollars, but it is an expense. But consider the expense up front is going to potentially save you much more expense that you'd have to deal with in terms of penalties and compliance issues. So testing, I think, is going to become one of the more important issues. If it's not top of mind for you now, I think it will be continuing to become top of mind as these regulations continue and take place and penalties start to increase. And then we've talked about some other of these issues here. Like I said, Prop 65, the PFAS could be an issue that federal courts say cannot be enforced. And if that were the case, that would be huge. That would be a huge thing for the industry. And that's kind of related to what I'm going to talk about next, microplastics. I think this one is probably more important than PFAS in the sense that I think it's going to be easier for the plaintiffs to push forward with testing. There's no specific microplastic. As you can see here, and some of you probably already know, different sizes, shapes, polymers are all different. But it's easy for a legislature or an agency to say, microplastics, bad, so regulate. And in fact, there was an article in the Washington Post yesterday by a doctor who said microplastics is one of his biggest concerns, along with issues like pollution and whatnot. So it's going to become an increasing thing in the press. And then I think it's going to become increasingly regulated, but regulated in what way is always the question. Well, in California, there's two things that are going to happen. Our state Department of Toxics has a consumer regulation law called Safer Consumer Products. And one of the proposed chemicals it has made is microplastics. Now, what does that mean? Well, once microplastics is added to that list of chemicals of concern, then that agency can determine what products they want to focus on, called a priority product. So, for example, if they decide, and you see here on the priority work plan, let's say they want to talk about paints and coatings. Paints and coatings then are the priority product, and they want to use microplastics, meaning if you've got paint or coatings and you have microplastics in it, microplastics, whatever that's going to mean, you need to report to the state. You may need to submit an alternative analysis to see if it can be manufactured without these. The state then has all this penalty ability. They can force you to put warnings. They can force reformulation, and they can force you to stop selling. Uh, this law, the Consumer Products Regulation, has been somewhat of a sleeper, but it's now starting to really gain some traction. And with this microplastics proposal, which probably will take about a year to get through rulemaking, if that gets finalized, that's going to be a big deal. Bigger deal will be Prop 65, because once it's added to the chemical list for microplastics, once microplastics is added to the list for Department of Toxics as a candidate chemical, it gets picked up by Prop 65. And so once it gets picked up by Prop 65, you have 1 year from the listing, then notices of violation can start. So I see that as the bigger concern. Outside California, there are microplastic regulations being proposed. At least 23 states are considering them. You see a couple of examples here, Illinois, Michigan. So there's also some overlap, right, with PFAS regulation, and you can see that in a few states as well. We just don't have enough time to cover all of microplastics, but I do think it's probably the bigger issue here in terms of what to worry about. Also, what to worry about: producer responsibility, EPR. As you know, if you're dealing with some of this, it's designed to be cradle to grave for a product's packaging. In other words, you are responsible for its life cycle and for the cost of its impact on the environment, the cost of its recycling. So it's designed for reusable and recycled packaging, and states are then able to force your company to comply by determining first if you're a producer under these laws. There are different definitions, but usually if you put it in the stream of commerce, you can be considered a producer, this packaging. And it then shifts the burden to you then to determine if you, as a producer, qualify for the EPR regulations and coverage. And that is based on your revenue or sales. In California, sales exceeding 1 million, you automatically qualifies you for coverage. Obviously, that's not a big amount in today's world. And so there's those 2 points. Does your company even use the packaging covered by these laws? That varies by state. So we need to find out what is covered in terms of packaging, what your sales are, what states have which deadlines and which thresholds for amounts. And then you take all that information, and then on top of that, you then have to join a producer responsibility organization. It's called Circular Action Alliance. That covers, as I understand it, most of the states that are doing EPRs. And what it does is all the companies that have to report then have to pay different fees based on their sales and revenue and whatnot. I talked with a client yesterday who, there are several states doing these laws, and they registered in 2 states, just 2. And each state was 60,000 or I think 50,000 for 50,000 for one, 60,000 for another. And that's just 2 states, and that's just 1 year. And so this can become very expensive. These laws are written with penalties attached, or severe penalties in some cases, but there's so much unknown about this. And I think that we're going to see a lot of retrenchment. We're going to see a lot of revisions on these. For example, the California law is just called SB 54. The state agency did its regulations. They were almost final, and the governor rejected it and said, go back to the drawing board and make this less onerous on defendants, or less onerous on business. I wouldn't say that the new proposed regulations are less onerous, but it does show that the states are starting to be cognizant of at what point have we gone too far. And that also shows that folks that are trying to comply with this are calling these states, and they're not getting answers because these agencies don't yet know how this is all going to work. And so grappling with this is going to become increasingly important, because some of the penalties can be quite severe. Those obviously haven't been used yet, but reporting deadlines have already passed in some of these states. And these are just a handful of states. Again, there's about 15 or so that are doing this. But the process is, do you qualify as a producer? If you do you have the right packaging? If you do, Which states are you doing business in? If you're doing business in the states that have this law, you're going to have to join a organization and pay a fee. You have to file a report with the state. There's deadlines. It gets very complicated very fast. And I put some of the links here to the states that have these EPR laws. You need to be familiar with them. And then there's some resources here. I have heard from that same client that they're not as helpful in terms of these resources, but they're not really finding any help anywhere, state or organization-wise. So I'm trying to work with a couple of clients right now and figure out what happens if we don't register. What are the penalties going to look like? If the state doesn't have a system in place, why should we have to join these organizations and pay all this money and file reports that nobody knows yet what the definitions are? So we're grappling with that. And so if you're grappling with that, you're not alone. But I do think they're going to take form in some way, but I do think we're going to see some changes. That doesn't change the fact that reporting requirements are there. That doesn't change the fact that there's potential penalties, nor does it change the fact that you would have to pay tens of thousands of dollars in most cases to join these organizations. So think about that. Right now, there's 15 states. Let's say, depending on the state you're in, you have to pay, 15, 20, 30,000. This quickly adds up, as I don't have to tell you, and becomes really, really expensive for the defense. And then if you add all the companies up and all these fees, is the state getting more than it should be getting? Where is the equity in that? And I asked that question without really an answer, but I do see that as a potential trend here. Are we actually taxing companies to do business here, not just dealing with the packaging at issue? We don't know yet. So anyway, I have a checklist here. As you can see, we've kind of went through most of this, but you need to go through those checklists and be familiar with the requirements. And again, if you're confused or if you're unsure, seek outside help, whether it's a lawyer, whether it's an agency, but don't do this on your own because it can really come back to bite you. And that goes for all these regulations. The goal is we want your company to thrive. We want you to avoid having to have penalties or be confused about compliance, because certainly there's enough stuff that we can all be confused about. Really quickly, chasing arrows. You've seen on the bottom of cups or plastic, there's the little arrows, the 3 chasing arrows. Here's some examples. I don't have it written here, but SB 343 is the California law, has very specific requirements that you need to meet so that you can carry the chasing arrow. And generally, that means that you can't have the higher numbers that are non-recyclable. So if you've got a number 6 here, and these are from the APR design guide, and that's the way that they determine the numbers, and the numbers are the most recyclable to the least recyclable. So check out 343, and it'll tell you which numbers are expected are allowed. So if you have an unrecyclable number in the chasing arrows, you're in violation. And then there's also penalties attached to that. So that's something to know if you're in that space. And then real quickly, misleading advertising claims. So you probably have seen or maybe even involved in these consumer class actions. They're increasing lately, and they're based on your product saying something like 100% natural, or your product saying low in fat. Those kinds of things then can get caught up in what the plaintiffs will say is misleading or fraudulent. And there's various state laws that then give them, the plaintiffs, the opening to come after a defendant. Unfair methods of competition, unfair or deceptive acts or practices. That's one of the California laws, the Legal Remedies Act. And they combine that in California with an unfair competition law. And it's things like, like I just said, low calorie, made in the USA, certification that it's been inspected. Those things can all then get you in trouble by the plaintiff then serving you a demand to revise or change your labeling. And if you don't, they can threaten a consumer class action. Those can be very expensive, as you can imagine, to defend and defeat. So one of the ways is you need to double check the advertising and the representations you're making. Sometimes they're frivolous and you have a defense there. Sometimes, even if they seem frivolous, they're not in terms of being able to move forward in the legal system. So it's not just California, it's other states. You need to be aware that these are potential areas and sometimes low-hanging fruit for the plaintiff. And one example is, I don't know if you've heard or remember, there was a false advertising case involving Red Bull. Did it give the person wings? He claimed it didn't. And there was actually, as you can see here, a $13 million settlement over it. So it can be very costly to handle these cases, but it's something that folks need to be aware of. If you've got any questions on how your representations on your product are coming out in terms of legality or potential to be into a misrepresentation, that's something you need to talk about with folks who are qualified in that area, because that can avoid you being on the next chopping block, if you will. Just a quick story. I have a client who makes bread products, and on the front of the product, it says protein, 9 grams or whatnot. But on the panel next, the food nutrition panel, as you remember, all those different things, protein is at the bottom. The law is, if you're going to have a protein claim on the front of your package, you have to have a percent daily value of protein on the panel. Now, that might sound like kind of a silly or trivial thing, but it actually is an actionable claim. There's been several court cases that have qualified as class actions, or several of these cases brought as class actions that have settled for millions, depending on the size of the company, the sales. One of those is the fake burger, I think is called alternative burger or something. It's not a meat burger. They settled. There's been a big pizza company that settled, frozen pizza. So this is an example of what you think is a little small thing that then turns into something that a plaintiff can sue you on. So bottom line, we're seeing more of that. We have to stay vigilant on it and look at ways to minimize it if you can. And speaking of minimize, let's talk about how do we minimize risk, right? So like I said, increasingly we're seeing state regulation in some of these areas. But again, as you saw with the example of Maine, Washington, and Minnesota, that's just 3 little examples of how states are regulating in different ways the same thing, right? Different deadlines for PFAS compliance, different reporting dates for EPR. And then we've got states then going out and doing their own thing, if you will, separate from this usual stuff. And what I mean by that is, okay, Prop 65, microplastics, PFAS, those are all kind of something that the states are regulating. They might be different, but they're all kind of in that area. Well, some states go beyond that. Washington State, for example, as you can see here, has a specific law on, lead in cosmetics and cookware, and then even cannabis has to have testing for metal. California has specific PFAS laws for cosmetics and for textiles. And other states are doing the same. New York has one as well, coming along in their legislature. So it's a patchwork. Then you have to worry about things like the federal preemption. The EPR and the California EPR has a specific issue with the agriculture department. And there's Prop 65 litigation that may be preempted. So there's many unknowns. Obviously, it can be risky and expensive to try to keep up with this. So what do? You got to have someone monitoring it if you don't already. If you do, great. But let's test that person or that agency. What are they using in terms of sources? Quiz them, stress test them, if you will, on regulations. Ask them where their sources are, and then review compliance. Are you being advised ahead of time of proposed legislation and deadlines? If you're not, then you're at risk. So if someone's monitoring in-house, go through those same questions. Let's all ask, how are you monitoring? What are you looking at? What's coming down the pike in terms of what states are proposing? Because if you don't have someone doing that, You can see just that one example we talked about with Minnesota, Washington, and Maine. That's being multiplied all over the country with all different types of chemicals and products. And it's only going to metastasize. Maybe that's not the right word, but I'm sure that's how it feels to some companies. So supplier certification, I realize that a lot of suppliers are foreign, and a lot of suppliers will not or don't have to test, and some of them will submit you a test that's not reliable. So what does that mean? Well, as we get more of these regulations, we're going to get more compliance. We're going to get more threats of penalties. If you don't know what's in your product, you're at a disadvantage. And again, I said earlier that testing is really important. I think it's going to become more important with each of these regulations and each of these deadlines and each of these penalties. You need to know what's in it. If you're selling a widget and the widget was supplied by China, the supplier doesn't know what's in it, won't tell you what's in it, releases it to you, and then you sell it in different parts of the country, you're taking a risk. Now, we don't exactly know what intentionally added PFAS is yet, but if your product has PFAS in it, that's something that a test can tell you. And then you have to determine, okay, if it has it, do I, for example, under Prop 65, do I warn for it, even if I don't know how much is in it, even if I don't know, even if I didn't add it myself? Those are questions that'll get settled, but they're not settled yet. And if you don't know what's in it, you can't even ask those questions or answer them. So that's something to really consider and look at. Now, we'll talk about testing on the next slide. It doesn't have to be a huge, expensive gambit. Finally, are indemnity agreements feasible? I'm surprised by the fact that a lot of clients that I've talked to don't realize they have that ability. You may not have that power. You may be dealing with a bigger company or whatnot, or a supplier that won't help. But if you've got the ability to look at an indemnity agreement, in other words, if you can get your supplier to sign off and certify that it is responsible for compliance with Prop 65 or PFAS or all state regulations, then that really puts you at an advantage. If you can't get your supplier to certify, sometimes the manufacturer will certify its product. By certify, that means they're taking an affirmative action to say we're in compliance. That's one thing. You can also require testing from your supplier at American labs or at certified labs to, again, push the responsibility to those who've made it or supply it without leaving you holding the bag. So that's something to look at on your agreements if you have like contracts with suppliers or manufacturers. So take a look at that. Okay, so I've talked about testing on and off. Let's talk just a bit about it. For Prop 65, for example, it's critical. You can't defend a matter if you don't know what's in it and at what level. I think it's going to be the same thing with microplastics. It's the same thing with PFAS. You have to understand the lab. Is it accredited? Is it using a method that's valid? Are you testing more than one? There's case law that has said that one test result is the same as no test result. Multiple tests, like 3 sample tests, usually are at least the minimum to give you a valid result. But again, like I said earlier, remember, just because a plaintiff has a test or because a state agency has a test doesn't mean that it's adequate, that it's valid, or that it was using the right test methods. We found out this in our food trials that the test that was being used and the lab that was being used by the plaintiff was shoddy. It didn't have the right procedures. It wasn't accredited to test what it was testing. It had never tested the product, that type of product before. It was making up the rules as it went along. And that's a lot on the line for your company. So my advice is in this area, if you don't have a testing lab that's accredited and testing for the product type that you've got, get a different lab. A lab needs to be able to explain to you what method they're using, how they're testing it, if they have experience testing it, and then you have some peace of mind in that. So again, when I say it doesn't have to break the bank, if you can come up with a method where you have a small limited number of products tested per lot, or maybe every other lot, or something like that, like 3 from a lot, 3 every other lot, whatnot, you can at least get yourself to a point where you have a defensible position and or know what's in your product. And those, of course, come in handy for all the different things we've talked about. So with that, I will say thank you for your time. I know this is a lot of information. Obviously, we didn't get to it all. There's all sorts of other things, and we'll cover that at some future time. But let me know if you have questions offline. I'm happy to answer. I want to help you and your business thrive. That's the bottom line. And I also have client alerts that I do. Let me know separately or drop me an email if you'd like to be added to those. And with that, I thank you for your time and have a great week.